name is Dontrel Williams.
Thank you.
Excuse me.
Yeah, we're going to arraign you on the charges being brought against you in just a moment. All right. There are 4 pending counts. It's alleged that on or about May 10th of 2017, in the city and county of Kalamazoo, Michigan, in count 1, that you did knowingly restrain a 13-year-old child with the intent to engage in criminal sexual penetration or criminal sexual contact with that person, contrary to the state statute. This is a Tier 3 offense under the Sex Offenders Registration Act if the victim is a minor. This charge is a felony. It has a possible penalty of life imprisonment or any term of years and or $50,000 as a fine and DNA to be taken upon arrest. This is the charge being brought against you in count 1 and the possible penalty you could face with the charge. Do you understand this is what you're charged with as well as the possible penalty for it?
Yes, ma'am. They said I was supposed to get a polygraph test for the count of.
I can't speak to that, but that's something you'll be able to talk to your attorney about, okay? We'll get to that in just a moment.
Okay.
But with respect to count 1, you understand that's what you're charged with as well as the possible penalty for that charge?
Yes.
The second count that's pending from that same date, time, location is the allegation that you did maliciously, forcibly, or fraudulently lead or take or carry away or decoy or entice away a child under the age of 14 with the intent to detain or conceal such child from its parent or guardian, contrary to state statute. Count 2 is the charge.
That's not true.
Okay, I'm not asking you whether it's true or not. I'm asking if you understand that you're being charged with it, and that's what we're going over right now, okay?
Oh, okay.
All right, count 2 is sometimes referred to as kidnapping by way of child enticement. This is a Tier 3 offense under the Sex Offenders Registration Act. This is also a felony with a possible penalty of life imprisonment or any term of years and DNA to be taken upon arrest.
The defendant comes into this court with very limited criminal history. However, the nature and the circumstances of this crime are extremely disturbing. Also, I represent to the court that under the Constitution provision, the court would have to find that the presumption of guilt is great, and I can represent to this court that the defendant has made admissions against his interest, which if found to be accurate by the jury, would have him convicted of these crimes. Therefore, it's the position of the people that the presumption of guilt is great in this case, and the court may apply Article 1, Section 15 of the Constitution and deny bond. Thank you.
All right. Mr. Williams, the prosecutor's been heard on bond. Did you want to address bond? Not anything regarding the pending charges themselves, or anything you'd like to say just with respect to the court setting bond, or not?
I was wondering if my mom's present.
I do not believe so.
Okay.